Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under we are under the law of succession. Law of succession. And the law of succession that we are looking at, we are going to look at the law of succession under family law 2, and we are going to look at the formalities of a valid will. Formalities of a valid will, all of them they are provided under section 47 of the Succession Act, the formalities of a valid will. And in this essence, what we are going to look at, they're like the elements of a valid will. You get? In contract, we see elements of a valid contract, but today we are going to look at elements of a valid will or formalities of a valid will. They are all invested under section 47 of the Succession Act. And one of them, which I can portray, first of all, is the signature. Before going to the signature, the requirement of writing. A will must be in writing. That's the general rule. It must be in writing, basically. You get? Any will must be in writing. Where you fail to put a will in writing, it cannot stand to the validity. But however, here we are looking at unprivileged wills, because they are the most popular. The execution of unprivileged will. We shall understand what unprivileged will in the types of wills. We shall realize what is unprivileged will and what is a privileged will. But let us just take it in the context of elements of a valid will. First of all, it must be in writing, however slight it is, whereby what the execution or this provision is under unprivileged will, unlike privileged will. And when you read, it may be on any material. You get? It may be on any material. You can even write your will on this pen. Basically, your will can be on this pen. For example, there is a case of in the estates of Murray, Murray, the estates of Murray. A will was written on a piece of a cardboard. You get? Even in the case of Hudson versus Barnes, Hudson versus Bill, the will was written on an eggshell. We all know what an eggshell is. Basically, here they say that the requirement of writing is necessary, but there's no provision that provides at what extent of writing, whereby anywhere you can write a will, basically. And basically, when you read the statutory format, it is recommended in the fourth schedule of the Succession Act. When you read the fourth schedule of the Succession Act, you get, because it is, however, it is customary way of writing wills, or to be set on paper. You get? It is a customary way that wills must be set on what? On a paper, basically. So it is for authenticity. Write a will on paper. If you're planning to make a will, write it on paper. Don't restrain. Why are you writing them on funny what? Materials. You get? So it is good you write a will on paper, basically. So if you're planning to make a will, you can make it as early as like this. You can make a call and I become the witness. As we are going to see that the next formality we have that the attestator or attestic signature. The signature of the attestator or the attestrix. You get the signature. What do I mean that the signature? The owner of the will, the one that is making a will, must put his signature on the will. Where a will fails to fall in these formalities, that will is invalid, and the person will be deemed to have died intestate, basically. So the signature, this is a requirement also provided under section 47 paragraph A. You get that the requirement of the signature is necessary in the presence, or actually it may also assign person to assign on his behalf, where that person cannot sign on his behalf or in his or her presence by his or her instructions or directions. Signature, even some people use the thumb. You can also use this thumb, you get, but a signature is more authentic. the one that you have on your national IDs, those that have national IDs. So basically, realize that we have a case, whereby you have the case of Smith versus Harris, which provided that someone can sign for himself, or he can get someone to sign on what? On his behalf. You get. And basically the reason as why a signature is necessary, it is an approval that the deceased is the one that affirmed to the will. You get. And this mark shall appear. It was intended thereby to give effect to the writing in the will, that mark. There's a law that says that each page must be signed on. You get. Each page must be signed on. You get. That although in a common law practice, they say that the testator write his or her name or fix his signature to the will, they have demonstrated it in the way that sometimes it can be slight, whereby a will runs in several pages. It is not required to sign on each page. But however, there's where they say that for authentic purposes, you have to assign on each page. For example, there's a case of relito, whereby the will contained 5 pages, and the attested, actually, the signature was put on the last page. You get. On the 5th page. So the question was whether that signature was effective. What tells you that it was effective? Since the last page was part of the rest of the pages. You get. Even similar in the goods of man. In the case of goods of man. In goods of man, this was a will that was written and put in an envelope. Unfortunately, the signature was put on the envelope. So the question was the signature put on the envelope effectual to the whole will? That was the question. But Eva Court lamented said that the envelope also intended to be part of the what? Of the will, which means that signature, the will was executed lawfully. So not that in mind in that case. So another requirement is that the attestator must sign. The requirement that the attestator must sign in the presence of the witnesses. Basically, that one we have seen it, that the attestators, first of all, we saw writing, we saw the attestator's signature, or the attestrates. Then another one, that the attestator must sign in the presence of what? Of the witnesses, of which the law provides that the witnesses must be 2, a minimum of 2. In the presence of witnesses, it is provided under section 47, paragraph C, whereby they provide that to sign the will in the presence of 2 signatures, both being present at the time, and to acknowledge his signature in the presence of such witnesses. The major emphasis is to ascertain that it is really the deceased that executed the will. You get. That's why they say that he must sign in the presence of the two witnesses, and all of them, they must be of sound mind. You get. Sound mind, adults, they must not be minors among others, and they must be keen, they must be looking. Actually, the element is that when he's signing, they must be eager. Actually, they must be on spot, seeing that it is really that is signing. You get. For example, when you read the case of Administrator General versus Bukirwa, that case, it provided that the presence of 2 witnesses provides a useful safeguard against forgery and the execution of a will under undue influence. Realize many people execute will under undue influence. Sons want property, what and what. So the reason that's why the sons must be present is to avoid such issues of forgery and undue influence. Then, there's a funny case of Brown versus Skiro. Brown versus Skiro. Skirrow. This is where the person took to sign his will in front of 2. He took the will to the grocery. You get. And when he took the will to the grocery, as he was signing, or you as she took, actually these were two shop attendants that he wanted them to be the witnesses. But as he was signing the document, one of the assistants was busy serving a customer. You get? It's like when he was signing, one of them was busy on his business that he was serving what? Customers. And he remained one witness. So the will was invalid. The reason being that the other witness didn't see what was happening because he was busy serving other what? Customers. So note that in mind. And also the quotation is, can a blind man be a witness? You get? That is the quotation. Can a blind man be a witness? Now the answer is here that where, actually, before even going there, in the case of Bukirwa, Anthony General versus Bukirwa, they say that in all administration cases, where a will has been executed in suspicious circumstances, the best evidence which the court will accept is concerning its due execution will be from one of the witnesses, basically, who attested to the will, except in cases where they cannot be what? They cannot be found, or they are dead. But even where the witnesses cannot be found or traced, the court will look for evidence from people who are present and witnessed the execution. So what they are trying to mean is that a witness is the clear evidence. Someone that witnessed that is the clear one that can say, really, I was present by the time they signed. That will is authentic. In cases where there is suspicions. So basically, there's also a case of Hudson versus Parker, which provides for a blind person, whereby it says that a blind person cannot be a witness. Hudson versus Parker. But when we read the case of R versus Gibson, sorry, Gibson, not R versus, it is Gibson. In the case of Gibson, it held, whereby they held that the codicil was invalid because the witness was blind. But however, they said that, however, where the testator's signature is signed or is written in braille, you know those blind people, there is those words that they can feel, and they understand that this is this, this is this. When the testator's signature is in braille, it can be acknowledged to a blind witness who is able to read such what? Writings. You get? So that it was the general rule, a blind person cannot be a witness. Now the exemption, when the signature is in braille and the blind person can read what? Such writings. And basically that's what I can provide. And a witness, in the words, must be mentally well. What you have to know, must be mentally well. For example, he must not be asleep, he must not be intoxicated, and he must not be of unsound what? Unsound mind, basically. So basically that is the second. The third requirement, whereby the testator must sign in presence of what? Of witnesses. So another requirement is that the witnesses must also sign on the will. That is also a requirement. Here we have seen that the testator has finished, then the witnesses must also sign, both of them. But here the technique here is that each witness must sign in the absence of another what? Witness. When one witness is signing, the other one must be absent. Absent, what do I mean by absent? Is that he must be outside. The other witness must be outside. You get? The reason is not to influence, to ensure that there is what? There is authenticity. You get? So basically note that in mind. And still it is under section 47C. The witnesses, by the process of attestation mentioned in this provision, they must also sign after the testator has what? Has signed. And if they don't sign, the will is invalid, basically. It is invalid. And basically here what you have to know is that the fact that it is signed by a witness before the testator had signed in, the presence of both witnesses or acknowledged by his signature, is that first of all they must first acknowledge the signature of the testator, then they also sign on the document differently. Read the case of White versus Berry. White is W-Y-A-T-T versus Berry. That case is good. And the testator must also be aware that the witnesses are signing the will. You get? The testator must be aware that the witnesses are also signing the will. So for some reason, the testator is so incapacitated for them to be conscious of the fact the signature is invalid of the witnesses. So note that in what? In mind, basically. But each witness must sign in the absence of the other witness. So other than that, those are some of the requirements of a what? Of a valid will. Those are some of the requirements of a valid will. And I thank you for watching. Thank you for listening. Thank you for listening. And thank you for being online. Those are some of the requirements of a valid what? Of a valid will. Stay blessed and good luck.